You are witnessing the precise instant when Judge Caldwell's patience shattered into 1,000 pieces after the mysterious Witness 14 recording surfaced early this morning. The defense attorneys didn't simply lose their argument in the courtroom. They lost something far more precious, their freedom. And here's exactly what that explosive tape contained. This is not conjecture. This is not hearsay. Federal marshals escorted 3 defense lawyers out of the courthouse in handcuffs right in the middle of active trial proceedings when a sitting federal judge commands the arrest of officers of the court on live television broadcast. Something absolutely catastrophic has just transpired. So what exactly triggered this unprecedented courtroom explosion that nobody saw coming at precisely 7:47 in the morning Eastern Time today? An encrypted audio file materialized simultaneously across 4 major whistleblower platforms. The file was labeled Witness 14. Privileged do not distribute. Within 90 minutes, it had been downloaded over 3 million times by people desperate to know what it contained. By 9:15 in the morning, the audio was broadcasting on every major news network across the country. That audio was Witness 14, the prosecution's star-protected witness speaking in a recorded conversation that was never supposed to exist in any form. This isn't just another courtroom drama unfolding before our eyes. This is what happens when the most protected witness in a federal corruption case gets recorded by the very attorneys sworn to protect their clients' interests. And what they discussed on that tape goes far beyond legal strategy or trial preparation. Judge Caldwell's reaction tells you everything you need to know about the severity of what was discovered. He didn't call a recess. He didn't issue a warning. He signaled United States Marshals and had the entire defense table placed under arrest before the morning break even arrived. In 37 years on the federal bench, he has never done anything remotely like this action. And I have the audio right here in my possession. I have the transcript. I have the court filings that dropped in the last 2 hours. Let me show you exactly what they're desperately trying to bury from public view. Here's what the Witness 14 tape actually reveals to anyone who listens carefully. The recording runs 11 minutes and 43 seconds, capturing a conversation between 3 individuals now confirmed as lead defense attorney Marcus Webb, associate counsel Daniel Haraman, and a third voice prosecutors have identified as an intermediary working for the defendant's business associates. This is it. This is what everyone is talking about right now. The first bombshell drops at the 2-minute, 14-second mark. Webb's voice, clear as day, states the witness needs to understand that cooperation has consequences, not legal consequences, but personal ones. Make sure that message is received before Thursday. That was a direct reference to Witness 14's scheduled testimony. According to prosecutors who reviewed the full recording, Webb then discusses specific details from sealed grand jury materials, details that only someone with inside access could possibly possess. At the 4-minute, 47-second mark, the third voice responds. The family situation has been made clear to him. Wife's employer, the kids' school enrollment. He understands what's at stake here. The tape documents what appears to be explicit witness tampering, obstruction of justice, and the disclosure of protected grand jury materials all in one conversation. But here's the most damaging part that seals their fate. At the 8-minute, 22-second mark, Haraman asks about payment arrangements, and Webb responds. The retainer covers this. It's been structured through the Consulting Limited Liability Company. Nothing traces back to us. Financial records subpoenaed this morning show wire transfers totaling $847,000 from an offshore entity directly connected to the defendant's former business partner. The timing of those transfers on January 3rd, 6th, and 12th of this year matches the dates referenced in the recording with disturbing precision. The Federal Bureau of Investigation's lead forensic audio analyst brought in within hours of the leak has already authenticated the recording beyond any reasonable doubt. Voice pattern analysis confirms Webb and Haraman with 99.2% certainty. The metadata indicates the recording was made on January 11th, 2026, just 5 days ago. But here's the kicker that changes everything. The recording device wasn't planted by law enforcement officials. It was placed by someone inside the defense team's own circle. Court filings suggest a junior paralegal with access to Webb's office may have been cooperating with prosecutors for months before this recording was made. Former federal prosecutor Amanda Chen told media outlets this afternoon that this represents one of the most brazen examples of witness intimidation I've ever seen documented in my entire career. They discussed threatening a protected witness's family while apparently knowing they were being paid through hidden channels. The arrogance is absolutely staggering and defies belief. The transcript continues with Webb providing specific instructions on how to approach witness 14's brother-in-law, who works as a contractor for a company that does business with the defendant's associates. Make it clear the contract renewals depend on reasonable behavior from the whole family, Webb says at the 9-minute 56-second mark, and it gets even worse from there. In the final 90 seconds, the three men discuss what to do if witness 14 doesn't respond to pressure tactics. Haraman suggests making an example of a different witness in an unrelated case. So word gets around the legal community. Webb's response is chilling, that's being handled separately by a different team. Legal analysts who reviewed these excerpts emphasize that this language suggests a systematic witness intimidation operation, not an isolated incident. If prosecutors can prove the different team reference points to additional criminal activity, this case could expand into a full racketeering investigation that encompasses dozens of people. The defense table didn't just cross a line according to every legal expert who has examined this evidence. They demolished it completely and irrevocably. This story is exploding by the hour, and I'm going to be releasing updates as the court filings drop. And trust me, based on what I'm seeing, the next 72 hours are going to be unprecedented in American legal history. Now, you've heard what's on the tape, but here's how we got here, and it makes this even more damning and disturbing. This trial began in late November 2025 as what appeared to be a straightforward federal corruption case. The defendant, real estate developer and political donor Victor Ashworth, faces charges of bribing local officials to secure zoning approvals and construction contracts worth hundreds of millions of dollars. Witness 14 was the linchpin of the prosecution's entire case, a former Ashworth Company executive who flipped after receiving a target letter from federal prosecutors. This witness possessed documentary evidence of cash payments, offshore accounts, and a network of shell companies used to funnel bribes to public officials. Tensions had been building for weeks, with aggressive defense motions to exclude key evidence, repeated attempts to unmask witness 14's identity, what prosecutors described as a campaign of legal harassment against government witnesses trying to do the right thing. Everything changed on January 6th, when Judge Caldwell denied the defense's fourth motion to reveal witness 14's identity in open court. In his ruling, he noted increasingly concerning patterns in defense counsel's approach to protected witness issues. According to court documents filed this morning, the Federal Bureau of Investigation had already opened a parallel investigation into the defense team on December 29th based on a confidential informant tip. That informant was the junior paralegal mentioned in the recording who had been wearing a wire for 3 weeks collecting evidence. This wasn't about aggressive lawyering or zealous advocacy. This was about a coordinated criminal conspiracy operating from inside the courtroom itself. On January 11th, the paralegal, whose identity remains sealed for their protection, recorded the conversation that leaked this morning, causing this massive explosion. Federal Bureau of Investigation agents reviewed the audio within hours but held off on making arrests to gather additional evidence and build a stronger case. The leak changed everything, according to sources close to the investigation. Sources indicate prosecutors had planned a controlled disclosure in sealed court proceedings later this week. Instead, someone possibly connected to the same whistleblower networks used by the paralegal pushed the recording into the public domain this morning, triggering this crisis. Marcus Webb, who founded his law firm 23 years ago and has represented some of the highest-profile white-collar defendants in the country, reportedly sat motionless as marshals approached his table. Daniel Haraman, a former federal prosecutor himself, who switched to defense work in 2019, allegedly attempted to address Judge Caldwell before being told to remain silent and not speak another word. The third attorney arrested, Junior Associate Priya Nakamura, appeared visibly shaken, according to courtroom observers. Her involvement in the recorded conspiracy remains unclear, though prosecutors indicated she possessed knowledge of the scheme and failed to report it as required by law and professional ethics rules. The bombshell moment came at 10:47 in the morning, and everyone in that courtroom will remember it for the rest of their lives. Judge Caldwell had just received a sealed filing from prosecutors containing the evidence. Court observers describe him reviewing the document for approximately 90 seconds, his face growing visibly darker with each page he turned. Then he looked up and said one word, "Marshals." The entire courtroom fell silent, as if someone had sucked all the air out of the room. 4 United States Marshals, who had been stationed near the exits, began moving toward the defense table with purpose. Webb rose to his feet, beginning to say something, reportedly starting with, "Your Honor, I must object to this." Judge Caldwell cut him off with a gavel strike so sharp that reporters in the gallery described it as sounding like a gunshot. echoing through the chamber. Mr. Webb, you will remain silent. You are being placed under arrest, Mr. Haraman. Ms. Nakamura, do not move and do not speak. Haraman's face reportedly drained of color in seconds. Nakamura began trembling visibly as the reality set in. Webb attempted once more to speak, but Judge Caldwell's response became the moment everyone is now replaying. Counsel, I have reviewed the evidence of your criminal conspiracy to obstruct justice, tamper with a federal witness, and violate every oath you swore when you became an officer of this court. Your voice is no longer welcome in my courtroom. Marshals, proceed with the arrests. Within 3 minutes, all three attorneys were in handcuffs being led away. Victor Ashworth, the defendant they were supposed to be protecting, sat alone at the defense table as his entire legal team was walked out in custody before his eyes. That's when it became clear this isn't just another courtroom scandal that will fade in a few days. This is the complete collapse of a legal defense through criminal self-destruction of the highest order. This isn't the first time defense attorneys have faced arrest for courtroom misconduct, but the scale and brazenness of this situation is virtually unprecedented in modern American legal history. Think back to the 1990s mob lawyer prosecutions that shocked the legal community. Several attorneys representing organized crime figures were eventually convicted of acting as house counsel for criminal enterprises, essentially becoming participants in their clients' ongoing crimes rather than legitimate legal representatives providing proper defense. Those cases established that attorney-client privilege does not protect lawyers who become active co-conspirators in criminal activity. Then there was the 2008 case of prominent Texas defense attorney Stephen Crawford, who was disbarred and sentenced to 15 years after prosecutors proved he helped his client intimidate witnesses through coded messages during jail visits. That case, however, involved a single attorney acting individually, making poor choices. The key difference now is this appears to be a coordinated effort involving multiple attorneys operating with institutional support from their law firm. The references on the tape to different teams and structured payments suggest something far more systematic than any previous case we've seen. More recently, in 2021, a defense attorney in Florida was removed from a murder trial after evidence emerged that she had contacted a witness's employer in an improper manner. She faced disbarment, not criminal prosecution, because the contact, while improper, didn't cross into explicit criminal threats against the witness. The Webb recording crosses that line repeatedly and explicitly throughout the entire conversation. Former federal judge Richard Howell, who served on the Ninth Circuit for 19 years, told media outlets this afternoon that in my entire career, I never saw anything like this unfolding. Defense attorneys threatening witnesses' families, discussing payoff structures, talking about making examples of people. This isn't aggressive advocacy. This is organized crime wearing a suit and tie. The pattern is clear, according to legal experts. When officers of the court become criminals themselves, the consequences destroy not just careers, but entire cases and public faith in the system. Now, however, the question becomes what happens to Victor Ashworth's trial moving forward. His entire defense has been arrested and removed from the case. Every strategy, every motion, every cross-examination prepared by Webb's team is now presumptively tainted by criminal conduct. The defendant didn't just lose his lawyers, he may have lost any chance at a fair trial under these circumstances. Legal experts are calling this morning's events extraordinary, unprecedented, and potentially case-defining for federal criminal procedure going forward. Professor Rachel Morrison, who teaches legal ethics at Yale Law School, told media outlets this afternoon that the implications extend far beyond this single case. What we're witnessing is the complete collapse of the attorney-client relationship's protective function. When your own lawyers are the criminals, every privilege, every protection, every strategic conversation becomes potential evidence against you in court. She added that Ashworth now faces an almost impossible legal situation that few defendants have ever confronted. Any new attorney who takes this case inherits a poisoned record. How do you prepare a defense when you don't know what your predecessor shared with the prosecution's witnesses or what deals were made? Meanwhile, former United States Attorney Jonathan Blackwell, who prosecuted white-collar criminals in the Southern District of New York for 15 years, emphasized the recording's significance for potential racketeering charges. The references to other teams handling other witnesses suggest this isn't isolated to one case. If prosecutors can establish that Webb's firm operated as part of a broader witness tampering enterprise, everyone who touched those payments, partners, associates, staff, could face conspiracy charges. Criminal defense attorney and legal commentator Victoria Santos added the perspective that many in the defense bar are privately discussing among themselves. This is a nightmare for everyone who does this work legitimately and ethically. Webb was considered one of the best in the business. 23 years, hundreds of cases, major victories in court. If he was doing this, what does that say about the pressure corrupting our profession? Santos noted that the fee structures described on the tape, consulting limited liability companies, offshore entities, structured retainers designed to obscure payments, suggest sophisticated awareness that the activities were criminal from the start. These aren't mistakes. This isn't poor judgment in the heat of the moment. This is a system designed from the start to hide crimes behind legitimate business structures. Even conservative legal commentator William Hardcastle, who has often criticized prosecutorial overreach, admitted on his podcast today that the evidence appears devastating and undeniable. "I've defended aggressive lawyering for 30 years," he said. "Aggressive isn't this. Threatening a witness. Children's school enrollment isn't advocacy. Discussing how to make examples of other witnesses isn't zealous representation. If this tape is authentic, and the Federal Bureau of Investigation says it is, then these men belong in prison alongside their client. The consensus among experts is nearly unanimous across the political spectrum. The tape is authentic, the conduct is criminal, and the only remaining questions involve how far the conspiracy extends and how many additional people will face charges in the coming weeks." Judge Caldwell's reaction, they agree, was entirely appropriate and arguably overdue, given the evidence presented. So what does this actually mean going forward for everyone involved in this case? First, Victor Ashworth's trial is in complete chaos with no clear path forward. Judge Caldwell declared a mistrial motion under advisement, but has not ruled on it yet. Ashworth's new legal representation, whoever agrees to take this catastrophe, will need weeks, possibly months, to review the case file and understand what happened. Every piece of evidence, every witness interview, every strategic decision made by Webb's team is now suspect and possibly tainted. Prosecutors have already indicated they may seek to use the defense team's communications as evidence against Ashworth himself, arguing that attorney-client privilege was forfeited when the attorneys became co-conspirators in criminal activity. If Judge Caldwell agrees, Ashworth faces the unprecedented nightmare of his own lawyer's words being used to convict him in court. Second, the Department of Justice is expanding its investigation dramatically beyond the original scope. Sources familiar with the matter told reporters this afternoon that a task force is being assembled to investigate what the recorded conversation called different teams. Federal Bureau of Investigation agents executed search warrants at Webb's law firm offices in Manhattan at approximately 2:30 in the afternoon today. Additional warrants are reportedly pending for the firm's satellite offices in Washington, District of Columbia, Miami, and Los Angeles. Every client Webb's firm has represented in the past 5 years may now face scrutiny regarding how their cases were handled. Third, the implications for witness protection protocols are enormous and far-reaching. Witness 14's identity, while still officially sealed, has been compromised by the threats on the recording. The threats discussed on the tape involving family members, employment, and school enrollment mean this witness and their extended family now require emergency protection from potential retaliation. Sources indicate the United States Marshal Service has already initiated relocation procedures for multiple individuals connected to witness 14. If this witness is permanently silenced through fear, harm, or disappearance, the prosecution's case against Ashworth collapses regardless of what happens to the defense team. Fourth, the legal profession itself faces a reckoning about ethics and accountability. Bar associations in New York, New Jersey, and the District of Columbia have all announced emergency proceedings regarding Webb, Haraman, and Nakamura. Beyond disbarment, which now appears certain civil liability looms over everyone involved. Every client Webb's firm represented may now have grounds to sue for malpractice and breach of fiduciary duty. Insurance carriers are already reviewing exposure and potential payouts. Legal industry analysts estimate the firm will be bankrupt within months. Under the weight of these scandals, the implications for public trust in the legal system are profound and deeply troubling. When officers of the court become the criminals, when the people sworn to uphold justice conspire to obstruct it, faith in the entire system erodes rapidly, and hanging over everything is a simple, devastating question that nobody wants to ask. How many other defense teams are doing exactly what Webb's team did? How many witnesses have been silenced before they could testify? How many cases have been corrupted by the very people sworn to pursue justice within ethical bounds? Nobody knows the answer. After today, everyone is asking these questions, and then the accused attorneys made it even worse with their public responses. Within hours of their arrest, statements began emerging from representatives speaking on the defendant's behalf, and the approach they chose was telling and desperate. Marcus Webb's personal attorney arriving at the federal detention facility told reporters, "This is a politically motivated prosecution designed to interfere with Mr. Webb's effective representation of his client. The recording is being taken completely out of context, and we will vigorously contest its admissibility and authenticity in court." That claim collapsed almost immediately under scrutiny when asked about the Federal Bureau of Investigation's voice authentication and metadata analysis. Webb's attorney declined to comment and rushed into the building, avoiding further questions. Daniel Haraman's spokesperson released a written statement calling the situation a grave misunderstanding and claiming Haraman has always conducted himself with the highest ethical standards throughout his career. The statement did not address any specific content from the recording itself. Here's the problem with these responses, according to legal experts. The tape speaks for itself with devastating clarity. When your voice is caught on an authenticated recording discussing threats to a witness's family, payment structures designed to hide your activities, and coordinated efforts to intimidate testimony. Claiming context isn't a defense. It's an admission that you said what you said and now you're desperate to explain it away. Legal ethics professor Amanda Chen, who reviewed the transcripts, pointed out that the statements themselves may constitute additional problems for the defendants. Claiming the recording is out of context implies the statements were made but meant something different. That's not how criminal defense of this evidence works in federal court. You either dispute authenticity or you explain conduct. Suggesting context while dodging specifics is the worst of both approaches. The defendant, Victor Ashworth, has remained silent throughout this entire ordeal. His family issued a brief statement expressing complete confidence in Victor's innocence and declining further comment. While the legal situation clarifies itself, court observers noted the irony of this situation. Ashworth's family is following proper legal crisis management while his own attorneys flailed publicly, making things worse. Meanwhile, Webb's law firm attempted to distance itself from the arrested partners to save what's left of their reputation. A statement from the firm's management committee expressed shock and dismay and announced an immediate internal investigation. 3 named partners have already resigned. According to legal industry sources, junior associates are reportedly fleeing to rival firms as quickly as they can secure new positions. When your defense becomes worse than silence, you've already lost the narrative battle. But beyond the immediate legal firestorm, this is really about something much bigger than one case. This is about whether the American justice system can survive when its own officers become the criminals they're supposed to prosecute. Defense attorneys exist to protect the accused from government overreach. That protection is fundamental to constitutional liberty in this country. Without zealous ethical advocacy, the government's power becomes unchecked and dangerous. Innocent people go to prison. Rights disappear. Justice dies a slow death. What Webb, Haraman, and apparently others did wasn't zealous advocacy for their client. It was the weaponization of legal privilege to commit crimes while wearing the costume of constitutional protection. If this goes unpunished, if high-powered attorneys can threaten witnesses, structure hidden payments, and coordinate intimidation campaigns while hiding behind attorney-client privilege, then that privilege becomes a license for any crime imaginable. Every witness who ever considered cooperating with prosecutors just watched what can happen to them and their families. Every victim who ever hoped the legal system might deliver justice just saw how easily it can be corrupted by those sworn to uphold it. This affects every American, regardless of political affiliation or feelings about this particular case, because if we can't trust officers of the court to act within the law, the court itself means nothing. The robe, the gavel, the oath, they only matter if the people wearing and wielding them honor what they represent. Here's where things stand. As of this afternoon, in the immediate aftermath, Marcus Webb, Daniel Haraman, and Priya Nakamura remain in federal custody awaiting arraignment on charges. Bail hearings are scheduled for tomorrow morning in the same courthouse where they were arrested. Legal analysts expect the government to argue for detention citing flight risk and the nature of the alleged crimes. Victor Ashworth's trial is suspended indefinitely with no clear timeline for resumption. Judge Caldwell has scheduled a status conference for Friday, January 17th, to address the mistrial motion and the question of new defense counsel. At least 4 prominent criminal defense attorneys have already publicly declined to take the case, citing conflicts and the, quote, toxic circumstances surrounding it. The Federal Bureau of Investigation is executing search warrants at Webb's law firm offices throughout the day. Agents were seen carrying boxes of documents and computer equipment from the Manhattan office throughout the afternoon. Sources indicate the investigation now involves at least 18 agents and 3 separate federal prosecutorial teams working together. Witness 14 and associated family members are being relocated under emergency United States Marshals protection. Their testimony, originally scheduled for next week, will be rescheduled pending security assessments. The whistleblower who originally leaked the recording, not the paralegal who made it, remains unidentified. Federal Bureau of Investigation officials told reporters they are not currently treating the leak itself as criminal, though that determination could change. State bar associations have initiated expedited disciplinary proceedings against all 3 attorneys. Suspension orders are expected within days. Permanent disbarment will follow criminal disposition. Keep a close eye on Friday's status conference. Judge Caldwell's decisions regarding new counsel, evidence taint, and the prosecution's ability to use defense team communications will shape everything that follows. The next 72 hours will determine whether this case can continue at all or whether it collapses under the weight of its own corruption. The stakes have never been higher. The evidence has never been more damning. 3 defense attorneys are in custody. A protected witness is in hiding. A major corruption trial is in chaos, and the American legal system is confronting its own reflection. What happens next will define whether officers of the court answer to the same laws they manipulate. This isn't just another courtroom scandal that will be forgotten. This is a test of whether justice applies to everyone, including the lawyers who claim to serve it. The reckoning is just beginning.